talking about the verdict, the jury's verdict out in Wisconsin in the Judge Dugan case for um, two counts, one of obstruction of justice and the other of concealing an individual to prevent arrest. And we're going to talk in a few minutes about the interplay between those two. But first and foremost, I want to have Adam from All Rise News talk about what he saw in that courtroom. So let's give him another 30 seconds or so to jump on. I hope the sound is better than it was in the interview that I just did with Representative Himes. I was told that the sound was not good, and I looked at the video, so we're going to run it through the magic editing machine to see if we can improve the sound before we post a final video of it. But I think I can hear Adam well, and I hope you all can as well. So let's get started. 3, 2, 1. All right. Welcome back, everybody. I'm thrilled to have Adam Klasfeld of All Rise News with us. He did wall-to-wall coverage in the courtroom out in Milwaukee, Wisconsin, of the criminal prosecution of a judge, Judge Dugan, for two counts, ultimately, that she was indicted on. One was concealing an individual to prevent arrest, and the other was obstruction of justice, really more directly obstructing an official proceeding, which is a 5-year maximum punishment, not a 20-year maximum punishment, which some obstruction of justice charges are. So, Adam, first of all, thanks for jumping on with us. And I'm really anxious to hear what Judge Dugan's defense looked like when she presented it yesterday, and then we'll move to the verdict.
So, thank you, Glenn, for that introduction and for having me on. Judge Dugan's defense really talked about the stakes of this. The closing arguments said, "Make no mistake, this goes all the way up to the top, all the way up the government." They said that they're trying to besmirch Judge Hannah Dugan's name. And by all accounts, folks in her court liked her, give or take one judge. We'll get back to that a little bit later. But her character witness was a very popular former mayor of the city I'm in right now, Milwaukee. Tom Barrett testified to her character. They spoke about how everyone was confused about federal ICE enforcement in the Milwaukee area, in courthouses, that the federal agents were confused, which is why when Judge Dugan directed them to the chief judge's office, they went there. The attorney for Dugan made the point that if this was so clear, if this was so routine, why did they follow her instructions to see the chief judge? They went after the credibility of one of the government's star witnesses, that other judge I was telling you about a little bit earlier, Judge Cristela Cervera, who had testified, and this was a quote that played during prosecution summations: "Judges shouldn't be helping criminal defendants evade arrest." And that was displayed very prominently in front of the jury in a big flash slide with a sketch of a judge holding her hand up and taking an oath. So it was a very powerful line and a damning line, because the jury heard from a fellow judge rhetorically convicting her. The Dugan defense called that a gratuitous comment that actually went against her credibility. Why express that opinion? As a matter of fact, the central issues of the case, when and where she instructed the people at that hallway, she was not an eyewitness to.
And let me add, I don't want to interrupt you, but not only a gratuitous comment. When you first shared that with me, I think it was yesterday, Adam, it felt to me like an inadmissible piece of testimony, because for 30 years, I had to navigate the rules of evidence. And ordinarily, you don't let a witness comment directly on whether the witness believes the defendant committed the crime, or, testifying to something that is tantamount to that opinion. So I suspect that will be a marquee issue on appeal, but please continue.
Yes. Well, I think to go to the what's next, since you opened that door, Glenn, I think one of the main points on appeal will be this split verdict, because Hannah Dugan was convicted of felony obstruction, and, to your point, obstruction of a proceeding, not of justice. They're different things. But she was acquitted of a misdemeanor count of concealment. And that had a lot of people scratching their heads. That I have seen legal commentators call it a repugnant verdict, not in the editorial sense, but in a sense that a repugnant verdict is a verdict that does not make, when you have a split decision, that makes no logical, cohesive sense. If I can give a kind of guide to the perplexed as to how the jury got that outcome, we saw two very interesting jury notes in quick succession on the day of the verdict. It was, as you noted, 6 hours of deliberations, and they asked in one of their notes whether they needed to find that Judge Dugan had known the identity of the subject of the arrest warrant to find her guilty on count one. And then the judge instructed them, after arguments from both sides, that the judge sided with the defense and said, yes, you need to, in order to convict on count one. Now, it wasn't said like that, it was just about arrest warrants. That you need to find that she knew the subject of the arrest warrant. And let's take a step back here, because this case is about an undocumented immigrant named Eduardo Flores Ruiz, who was in her courtroom on April 18th. And the prosecution had alleged, and the jury found, essentially with her verdict, that she had obstructed his arrest by leading him through a jury door in the back of her courtroom through a restricted hallway, and that hallway, there were two ways out. One was through the public hallway, where a side door that entered into a public hallway where the agents were waiting, and another to a private stairwell. And that the intention, prosecutor said, was to lead him into a private stairwell. And the defense said, well, if she doesn't know whose proceeding she's trying to obstruct, and she doesn't know the subject of the arrest, how can she conceal him? That's count one. The judge found, yes, you need to find that she knew that the subject of the arrest warrant was Eduardo Flores Ruiz. Now, count two, the felony count. That required, the jury want to know, did they need to find, and I apologize to folks, it's hyper technical, but it matters. It matters a lot. The jury asked, do they need to find that that Judge Dugan knew this identity of the subject of the pending proceeding? Now, that has a different legal standard, and that instruction did not go as well for the defense. And the Judge Edelman gave an instruction that wasn't a clear yes. It was she had to be sufficiently aware about the nature of the proceeding. So why are we getting a not guilty verdict on count one and a guilty verdict on count two? Only the jury can tell you, and we'll see if they open up to the local press here. The Milwaukee Sentinel Journal is a paper I'll be reading in the coming days. However, from their notes, from their voice that came in a public courtroom, you can see the line. You can see count one, them finding not guilty after being told by a judge. She didn't need to know it was Eduardo Flores Ruiz. She just needed to know that she wanted to allegedly obstruct ICE. And count two did not have that bar. And that, unfortunately for her, was the 5-year count. That was the felony count.
Okay, Adam, I'm an officer of the court, so I'm duty bound to tell the truth. So the first thing I want to say is that was a brilliant explanation of what some people would view as an inconsistent verdict. I'm going to talk about the doctrine of inconsistent verdicts in a minute. But the other thing I have to note is that you may have just given yourself a tagline that I am going to forever use for you. You said that you're going to be a guide to the perplexed. And if ever we need a guide to the perplexed in this day and age, it is somebody like Adam. So here's what I want to say. There's so much to unpack here. Let me start with the inconsistent verdicts, and then I want to go more fundamentally to the nature of obstructing a proceeding. So I taught for 9 years at George Washington University, 4 years at the School of Law, 5 years undergrad. including the doctrine of inconsistent verdicts. This feels inconsistent, as you point out, because count one is concealing an individual to prevent arrest, and count two is obstructing a proceeding by concealing an individual to prevent arrest. Wait. How can you say guilty of one, not guilty of the other? It doesn't make any intellectual sense. It doesn't feel consistent. Here's what I would teach my GW students undergrad. I would say, just think about this hypothetical. Somebody on the street in DC walks up to a would-be victim, punches the victim and takes the victim's wallet and runs. So that is basically a robbery, but the way we would charge it is assault for the punch, theft for taking the wallet, and robbery, which is defined as using force or violence or threats to take the property from another person, the immediate possession of the person without any lawful authority. So the punch, the theft of the wallet, it feels like one criminal act, but it will be charged as three separate crimes. The Supreme Court has said inconsistent verdicts are just fine. So you could actually have a jury say, we're going to convict of the robbery, but we're not going to convict of the punch. And people are like, wait a minute. That's inconsistent. But the Supreme Court has held, inconsistency among verdicts is no reason to impeach a jury's verdict because it could be the product of negotiations among the jurors during the deliberation. Look, we're gonna bang this person out for one guilty verdict, but we don't feel right sort of banging them out on all three. And they're allowed to do that. And you can't pierce the veil of jury secrecy. So it feels inconsistent, but that, in my opinion, and I think my friend Joyce Vance would hopefully back me up on this, that is not a reason to challenge the verdict on appeal because they were inconsistent verdicts. It will certainly be raised on appeal, but I don't think it will be successful. Now, let me talk more fundamentally about obstructing a proceeding. My first question, and I'm so interested in whether the judge defined for the jury what a proceeding is, because this to me, and there is case law in DC that says if you interfere in an investigation, that's not necessarily a proceeding. But I was wondering if the judge defined what is a proceeding for the jury.
Right. I don't have the jury instructions in front of me. I will say to your point, Glenn, it was a contested issue when those were being defined. I would expect for it to come up on appeal. Another issue that will come up on appeal, materiality. For example, what we know, the undisputed evidence is that Eduardo Flores Ruiz exited with his attorney, Mercedes de la Rosa, into a public hallway where federal agents were waiting for him. He walked right by them. One of them was not even aware that he hadn't exited through the main entrance. And so where is the obstruction, is the argument that the defense argued and lost on at the trial court level. I expect them to bring it up. And I wanted to just kind of close the loop on one quick thing on the inconsistent verdict. And you're absolutely right with the Supreme Court. I do know they're going to raise it on appeal, and I want to add just a little more color to this one point because during the litigation over the jury instruction, let's take two things in about the significance, if that is the skeleton key for understanding the different verdicts. It means that the jury was not persuaded that she knew that Eduardo Flores Ruiz was the person identified in that warrant. And what the argument from her attorney was that it's a matter of notice that the indictment itself, if you read the indictment, both of the charges mention that the pending proceeding in count two related to Eduardo Flores Ruiz. She said, quote, it's a constitutional issue. And they did raise that in their statement to the press. So I imagine whether it's going to be successful or not, it's going to be raised on appeal. And I'll say one more piece of color on this, maybe two, is that when she got the favorable instruction, the instruction that led to that not guilty verdict on count one, she knew it was good for her. She stood up, smiled broadly. She did not know what was going to come with that second count. And another thing where you just had to be in the courtroom to know the significance of these things. When the jury was walking in, no eye contact with the defendant.
Yeah, that's a sure sign because when they are not only looking at the defendant, maybe even with I don't want to say a pleased look or a smile, but a content look on their face, like they're not pained, or if they look out into the audience at the defendant's friends, families, supporters, and I've had that happen so many times. That is a signal that it's probably going to be a not guilty verdict. So, but let me just do this. For my own edification and hopefully for our viewers. When I looked at the two charges, I thought, concealing an individual, even though we can quibble with concealing, it's not like she, put the guy in the trunk of her car and then drove him away so he could, ICE couldn't apprehend him. But she did, it sounds like a little bit of misdirection, go out the side door. There was an opportunity for him to, go down a stairwell and avoid the agents who were in the public hallway altogether. Of course, he didn't do that. But concealing an individual to prevent arrest. Okay, it felt like there may be a little bit of that going on based on the evidence that I saw, but obstructing a proceeding, and I'm going to use the term obstructing justice because I think that's more familiar to people. That to me felt like an overreach. Here's why. I've prosecuted a lot of obstruction of justice cases. They ordinarily are charges that are attached to, attendant to other crimes. For example, white collar crime. Somebody is, indicted for bilking, customers out of millions or billions of dollars in a white collar fraud scheme. And then what do they do? Maybe before they're arrested, before they're indicted, when they know there's an investigation, they start shredding documents. They're trying to get rid of the evidence. What is that? It's obstructing justice, right? In the setting of a violent crime case, you have a witness who saw the defendant commit the murder, let's say, and then the defendant or the defendant's associates go about threatening or intimidating, or unfortunately, I had multiple witnesses killed because they were, quote, snitches, they were witnesses. That's obstruction of justice. It's also other substantive crimes as well. So we often see obstruction and we think of getting rid of the evidence. We think of intimidating the witnesses. We think of something that the criminal does to try to get away with the crime. So when I heard obstruction, which is, why don't you go out the side door, which led to the public corridor, and the person was apprehended, I said, boy, this feels like a pretty significant prosecutorial overreach, as opposed to they did something to interfere with the apprehension. And of course, the jury kind of flipped it for reasons that you explain perfectly. It all has to do with the elements of the crime and the way the judge defines those elements to the jury. And the way you explain it, it kind of makes sense to me now as an old prosecutor that they found the defendant guilty of one but not of the other. And I know also on appeal, there will likely be an attack, a challenge on the judicial immunity ruling that allowed Judge Dugan to be tried in the first place. I'm not so sure that will be successful either, but I'm quite confident that the attack for inconsistent verdicts will not be a winning argument on appeal. Okay, so Adam, the next question moving forward is, do we have a sentencing date and do we have any sense of what to expect at the sentencing hearing by way of what the prosecutors might ask for, for a sentence, for a punishment for this offense of conviction?
Right. So we don't have a sentencing date set. Judge Edelman has not set one, so we'll find out as the days go on. He still has a pending motion for a directed verdict, and they have asked, and through that motion, we can see what they are going to argue on appeal and down the road. I think that they are going to the Trump administration and the DOJ, they threw the book at her. They threw a felony charge and a misdemeanor charge. They called nearly 20 witnesses, and one of whom, actually, excuse me, two of whom were fellow judges in her courtroom, including the chief judge. They got everyone who could have witnessed an incident where, as you noted, the defendant was apprehended. What are they going to ask for? I bet they'll ask for a lot. She is facing up to 5 years. So I doubt that she would get anything near that, but I would not expect them to try to lowball a sentence. This is the Justice Department in this year, but we'll wait and see. I expect Judge Dugan's defense attorneys to point out that Eduardo Flores Ruiz was in fact apprehended. He entered into a public hallway. Whether there was, and yes, there was evidence through a grainy audio that where she could be heard saying, "I'll do it. I'll take the heat." There was a reference to down the stairs, a reference to the wrong door. They put the court reporter on the stand who clearly didn't want to be there, clearly liked Dugan, but had to deliver a fateful testimony saying the wrong door was the door where the agents were waiting for the defendant. So I think that they're going to argue materiality, even if they lose on the merits of it, that the fact that there wasn't any real harm should lead to a lenient sentence, that Dugan was not at fault for the fact that the defendant wasn't apprehended until after they left the courthouse. It was a rainy day. We heard lots of testimony about how it posed a safety risk that the 6-member team was diverted because Dugan referred them to the chief judge's office. But there were 2 members of that team there. One of them rode an elevator with Flores Ruiz. I imagine they're going to argue that if there's any moment that materiality should come into play, it's on sentencing, where we're looking at what are we talking about here? We're talking about an incident where a defendant exited through a side door right in front of the agents instead of the main door, which was less than 12 feet away. And that we're dealing with something that has to do with a very controversial policy of ICE arrests in courthouses, which upset many of the judges, 4 of whom testified at the trial. The chief judge sent out a scathing press release about how this was chilling access to justice from the
Yeah.
immigrant community and how this poses a very serious threat to the state judiciary. We heard one of the things where I would say it was a defeat for the government in the court of public opinion, if folks were to pay attention to the actual facts that came out at the trial, is they claimed throughout the trial, from the beginning to the end, that this was routine, that this was an ordinary occurrence, and the evidence, that was not evidence that the jury voted on. But I imagine if it was before them, they would say that laughable, if that were an option. That, as a matter of fact, we saw copious evidence that everyone was confused, that the judges were confused about what to do. They had a draft policy that never became a final policy. They were taking primers and trainings on how to deal with the thorny issues of federal supremacy and state sovereignty, and where is the line drawn? What can they challenge? What can they not challenge? And for the defense, that was reasonable doubt. That's not what the jury found. And we will see what happens, but there's what happened in the courtroom, and how what happened in the courtroom will shape our understanding of these national trends that aren't going away.
Yeah, and so the one thing I will say is my entire career, I was in the practice of having to accept jury verdicts. And I'll tell you, there's nothing more painful than when, after I lost the case, I still had to step to the cameras on the courthouse steps and thank the witnesses, thank law enforcement, thank the jurors for their service, even if they reached a decision with which I disagreed. I would mourn for the victims, the family members of the victims, and for the community. But we have to accept jury verdicts, and I'm prepared to accept this one, even if I, doesn't feel entirely righteous to me. I didn't sit through the
Mm,
trial the way you did. And I also do not, I think the way the Trump administration is doing immigration enforcement is doing such deep and lasting harm to our nation, to the American people, to the citizens who are being unlawfully detained until ICE realizes they're U.S. citizens, to the documented immigrants, to the undocumented immigrants, to the economy. I mean, this is not business as usual, and it's not the way immigration enforcement should be done, in my opinion. But I have to accept the verdict. The other thing I'll say is, this is a 5-year maximum prison term for this offense of conviction. I believe it's also a probation eligible offense. And I am assuming, because she was a judge, that Judge Dugan has no criminal history. What will happen next is there will be what's called a pre sentence report generated, which is a soup to nuts recitation of not only the evidence that was introduced at trial, but Judge Dugan's employment history or family history or educational history, her work history, all of that. And it's really a soup to nuts account of who the offender is, who is now facing up to 5 years in prison. And pre sentence reports can run, 20, 25, 30, 40, 50 pages. They are prepared to inform the judge when the judge has to make the difficult decision of what is the right sentence. If I had to bet my $1, and Adam, I am not a high roller, I'm not a gambling man, $1 is my betting limit. I'm going to put a good 90 cents of my $1 max bet on a sentence to probation
mhm.
for this offense. But we will see. We will come back to you when there are any significant developments, including any motions, hearings, or rulings by the judge that might impact the case before it reaches sentencing. And then certainly when the sentencing occurs, we'll reach back to you. So thank you for bringing us all the color commentary, the inside baseball, and the legalities of what played out in the Judge Dugan prosecution.
Oh, thank you for having me, Glenn. Always a pleasure chatting.
And as I tell everybody, please click over if you have a minute and subscribe, follow, support Adam Klasfeld and All Rise News, because, where else are we going to get somebody who provides a guide to the perplexed?
Mm.
So thank you. And enjoy your remaining time out there in Wisconsin.
Thank you. Will do.